Well, good afternoon, and welcome to this afternoon's webinar presented by Beresford Booth. My name is Per Oscarsson. I'm a member of the Business Mergers and Acquisitions group here at the firm. My topic today is converting Washington entities. So we're going to start with what are those entities? And the ones that are probably most familiar: corporations, limited liability companies, partnerships, and you see there I've got on the screen general and limited liability. By partnership here, I mean a general partnership where you just have general partners who would have each would have personal liability. A limited liability partnership is the same kind of partnership, but the partners typically don't have personal liability to any third parties for anything the partnership may do. They would have personal liability for what they may do, but not what the partnership may do. There's also limited partnerships where you have a general partner and one or more limited partners, where the limited partners have limited liability similar to what they would have if they were a member, shareholder of a corporation or a member of a limited liability company. There are also limited liability limited partnerships where in the typical limited partnership, the general partner or general partners have personal liability to third parties. But with a limited liability limited partnership, the general partners do not have that kind of liability. I've also included two other types of entities on the screen: joint stock companies and profit unincorporated associations. They fit in this category a lot less than the four that are mentioned, and so I won't be talking much about converting any of those types of entities. Conversion of entities is kind of a relatively new concept. For Washington partnerships, it's been possible since 1998, and it allowed for converting a partnership or general partnership to a limited partnership, and a limited partnership converting to a partnership. Corporations were allowed to convert to some other form of entity starting in 2014. Limited liability companies in 2015. You'll see that the statutes that deal with conversion of primarily limited partnerships, corporations, and limited liability companies allow for conversion into just about any other type of entity. General partnerships are limited in that general partnership can convert to a limited partnership, but not into any other form of entity. And a limited partnership can convert to a partnership, but also has flexibility to convert into some other form of entity. And again, what kind of form of entity that they can convert into will also depend upon the statute or the statutes that govern the form of entity into which the entity is being converted. So we have the jurisdictional issues are, at least for purposes of the statute, we have domestic entities, which are those that are formed in Washington, in the state of Washington, and foreign entities, which are any jurisdiction other than Washington, which is not surprising. But foreign does not necessarily mean from another country. It could be another US state, or it could be the United States, because there are some entities that can be formed under United States law. So a lot of people are probably more familiar with the concept of merger versus conversion. Merger is when two or more entities combine into an existing entity, which results in a surviving entity, and the other entity or entities that are parties to that merger, they disappear when the merger is effective. Conversion, on the other hand, is just one entity converting from one form of entity into another form of entity. And today we're just going to focus on conversions. So there are a number of reasons for potentially converting an entity into another form of entity. Flexibility. One example would be a corporation converting into a limited liability company. in both situations, the owners of those entities, the shareholders of the corporation, and the members of the limited liability company, they have limited liability. But corporations tend to be much more rigid in how they operate for a variety of reasons, whether it be legal reasons or tax reasons. There is a little bit more flexibility for a limited liability company in its operations, and also a little bit more flexibility in some of the tax issues that can affect them. So a corporation may change or convert into a limited liability company to take advantage of that greater flexibility. Asset protection is another reason why an entity may convert. Most of these entities that I talked about, the entity owns its assets. Partnerships, it was at one point, it was the partners had interest in the partnership property, but there wasn't a protective shield effectively around those assets. Corporations, limited liability companies, limited partnerships, on the other hand, the assets belong to the entity, and there is a kind of a shield, a legal shield of protection around those assets, and also protects the owners of those entities in whatever form, whether it be shareholder, member, partner, protects their personal assets from liability for the entity obligations. There could be tax reasons for making the conversion. I'm not a tax attorney, but I know that there are a number of things where there are benefits to being in one form of entity than in another form of entity, and it may be appropriate to take advantage of that tax advantage provided by an entity into which the entity converts. There may also be legal restrictions on an entity. For example, in some places, certain types of entities cannot own particular types of real estate. Sometimes agriculture is one of those. But it may be appropriate for another form of entity to be able to own that type of property. And if the property or if the entities can convert, then they can become a proper form for purposes of ownership of the property. So the process for converting is unsurprisingly very similar to mergers. It is provided by statute, and here on the screen you see the statutes that govern not just conversion, but govern those entities generally. So corporations are governed by Revised Code of Washington, Chapter 23B, limited liability companies by RCW 25, Chapter 25.15, partnerships by RCW Chapter 25.05, and limited partnerships by RCW 25.10. But these statutes also include the statutes that set forth the conversion process. And so the start of that process is to have a plan of conversion. And this is not necessarily something that you're looking at hundreds of pages. This could be, depending upon the nature of the entities involved, it could be a very short document. It identifies the name and form of the organization or entity before the conversion, the name and form of the organization after conversion, the terms and conditions of the conversion. And that may include, for example, if you're changing from, say, a limited partnership into a limited liability company, as a partner in the limited partnership, you have partnership interests. But in an LLC, you have membership interests. And so the plan of conversion will provide for how do the partnership interests become membership interests in the LLC upon the conversion. And it may be as simple as, well, the partnership interests, if it's the same people involved and they're going to have exactly the same proportionate shares of ownership in the converted entity, it may be just as simple as saying the interests in the entity that is converting will just be canceled upon conversion, and they will become interests in the other form of entity. There will probably also be organizational documents required for the converted entity. So for example, in my example of a limited partnership converting to a limited liability company, there would have to be a certificate of formation that is done for the limited liability company and filed in Washington with the Secretary of State's office as if the limited liability company was being formed initially. Then the next part is an approval of that plan of conversion. And when it's a corporation, the board of directors would need to approve it. And then the shareholders of the corporation would also need to approve. In a limited liability company, all the members of the limited liability company would have to approve it. And this could be done in the form of a members meeting. If there are very few members, sometimes even just a sole member, it can be done by a consent in lieu of meeting. Same would hold true for a corporation. In a partnership, all the partners would have to approve it. And in a limited partnership, all of the partners, both general and limited, would need to approve the proposed conversion. Then there'd be the filing of appropriate documents with the Washington Secretary of State. Usually this is articles of conversion to reflect that the entity that did exist in this particular form is now changing to this particular form. And it may also require filing of appropriate documents in a foreign jurisdiction, because it is possible to have a Washington entity and a foreign entity be the converting and converted entities, as long as, of course, the statutes of both allow for it. And so if the converting entity ends up being a foreign entity upon conversion, there may be filing requirements in that state. Same is true as if you've got a foreign entity that is converting into a Washington entity. There may be some documents that will have to be filed with the Washington Secretary of State. Conversion, and again, very similarly to mergers, there is an effect, or several effects of conversion. I have not provided a complete list, and of course this will vary depending upon the nature of the entity that's being converted. But generally, the entity that results from conversion is the same entity as it was before the conversion, unless the converting entity has otherwise agreed, or if it's otherwise required under non-Washington law. The converting entity is not required to pay its liabilities and distribute assets as part of the conversion. Sometimes, depending upon the nature of a transaction, it can be required that they take care of all outstanding liabilities. However, since the entity is still effectively the same entity after the conversion as before, it still has those liabilities, and it will most likely then pay them in the ordinary course of business. Conversion is deemed not to be a dissolution of the converting entity. And as I just mentioned, title to all real estate and other property remains vested in the converting entity. And very often, for example, if the entity owns real estate, well, one would think, well, wait a second, we've got a deed, but the deed may be and will be into the converting entity, but now it doesn't look like that anymore. Very often, there's no new deed that is recorded to reflect the new name, but when the converted entity then transfers its property, it would identify itself under its new name, but also indicate that it took title to the real property under the name and form of entity under which it took title. So, for example, if it took title as a limited partnership, ABC Limited Partnership, and is now XYZ LLC, when XYZ LLC transfers the property, it would identify itself as the grantor XYZ LLC, which took title as ABC Limited Partnership. Title companies will normally accept that without too much question. It may be confusing to the general public because you've got two different entities named there, but title companies are looking to see that there is a proper chain of title for the real estate, and that will certainly help with that determination. The debts and liabilities of the converting entity remain the debts and liabilities of the converted entity. The rights of creditors and liens on all the property are also to remain unchanged, and they continue as the obligations of the converted entity. And then if the entity that is converting may have been involved in some sort of proceeding, whether it be a lawsuit in court or some proceeding before some governmental agency, and it could be that the converting entity is the initiating party or the defending party in either of those, that action or proceeding will continue with the converted entity remaining as a party to that proceeding. With that, I've concluded my brief presentation on the conversion of Washington entities. If you have any questions, I hope you'll direct them to one of our business lawyers here at the firm. And I invite you to join Ryan Foltz of our litigation group next week when he will present a webinar on alternatives to traditional litigation. Thank you very much.